I think it's the fourth in the series of managing IP disputes for insights for corporate counsel. I am Lindsay Heaton. I'm counsel at Procopio. My practice is IP litigation, trademark copyright litigation, and some trade secret litigation mixed in there, as well as general commercial litigation. And with me today is Scott Leonardo. Leonardo, sorry about that, Scott, head of litigation, IP and product at Asana. Um, we are going to go through generally litigation strategies and tips and insights for in-house counsel when you're thinking about how to manage IP litigation and how to drive effective outcomes and results. Let me just get my slideshow started again, and we will get going. And we promise to have you done before England v. Croatia starts. Um, One of the things, oh, and Scott, if you want to handle any questions that come up in the chat, because when I have it in this mode, it's not letting me see my screen. So,
Yeah, for sure.
yes, and we did want to invite people that if you do have questions or thoughts, you can drop them in the chat. You can unmute yourself. We'd like this to be as much of a Q&A as possible. Um, okay. So today we're going to go over understanding leverage in IP disputes, offensive and defensive litigation tools, form selection and procedural strategy, injunctive relief and emergency remedies, and just overall practical guidance for in-house counsel. Um, where this fits in the series, there's already been part 1, 2, and 3, dispute management, IP strategy, and litigation economics. And we're here, part 4, litigation tools and leverage. And we hope that you will join as well for the 5th part coming up, I believe, next month on damages and remedies. So I think everybody here understands that litigation strategy matters, and we're going to dive into particular stages of IP litigation and what strategic decisions are being faced and how to think about them in a way that positions your client and yourselves as in-house counsel in the best position to advise. So we'll go over procedural and strategic decisions that can create decisive leverage if used appropriately. Sophisticated litigants are going to be using multiple tools simultaneously. Often procedure is more strategic than you might think at the outset. And and this is the bedrock, as you'll see throughout the slides and throughout our discussions, that litigation should support business objectives, not become the objective. Okay, so building leverage. In general, in an IP dispute, there are several different factors that create leverage. Um, at the top, we have the strength and scope of the IP rights at issue. Certainly, understanding exactly what rights you have that you are seeking to protect, or the rights of the opposing party that you're being accused of infringing, understanding the strength on both sides very early on in the case, as much as possible, is of course paramount, and as far as the subject matter of the case. Um, there's also form selection and procedural posture, timing and sequencing of actions. When are you filing? Are you engaging in any pre-suit back and forth cease and desist letters beforehand? Potential business disruption um, and risk of injunctive relief if you're on the defensive side, and the benefit of injunctive relief if you're on the affirmative side of the case. Scott, did you want to talk a little bit about, I know in our prep session we were going over which of these pieces, how each of these pieces create leverage, and form selection and procedural posture is one that definitely comes up a lot.
Yeah, thanks, Lindsay. And hi, everyone. I'm Scott. As Lindsay said, I'm in-house at Asana. But just by way of background, I spent many years, probably too many years, at law firms doing IP litigation, mostly trademark and patent, but then also some trade secret and copyright as well. And I would echo Lindsay in saying that this is a pretty small group. We all have different experiences and things to add, so would definitely encourage you all to come off of mute if you want to, and add any thoughts or ask questions in chat because I think we can all learn from each other. But yeah, in terms of these, these five kind of points, um, we've talked a lot, or Lindsay and I in our prep session talked a lot about venue being a really important consideration. And I think in my experience, it's important in patent cases. I don't think I've ever really considered venue as much in trademark or copyright cases, other than the usual considerations of wanting to be in your home jurisdiction. But as everyone knows, in patent cases, the venue makes a huge difference. Um, And, obviously injunctive relief, I think, is another key factor. So I think of these, like those are maybe two of the most important considerations at the outset. Obviously, they're all important, but I think those are maybe the first couple that you might look at if you are either considering filing a case or facing a potential threat. Um, one thing to note for venue, I think it's important to consider both the judge, the judges you might get in the district, but also the jury. I think it's good to consider that anytime you have a case filed against you, you should assume it might go to trial, even though only a very small percentage do. I've had a few experiences where venue's been really critical in cases, and in one, we actually filed a DJ or declaratory judgment action in our home district. Um, the plaintiff or the potential plaintiff was in kind of a smaller district where they were a big company, well known. So we wanted to keep it out of that district. Um, in that case, we ended up having the case transferred to their home district. The case did go to a jury trial, and that really became a really important factor in the outcome. It was very clear, that this was a well-known company. The jury, it's hard to say exactly what motivated them, but it kind of throughout the case, it became an issue, and I think that really was an important consideration.
Yeah, that's a really good point. And you're often going to be um, thinking about forum if you're bringing a case as a plaintiff. Where are the defendants? Where do you want to be? Where are you maybe going to end up, even if you do file in one jurisdiction over the other? What are the risks? Do you want to have to deal with motion to transfer or forum nonconvenience or personal jurisdiction arguments? Okay. Um, one of the pieces here that we talked a little bit about, or I mentioned as we were going over to these slides initially, is potential for business disruption. Oftentimes, you have a business side of your company who you're advising on this, and maybe they're really aggressive and they're like, they're using our information. We created this. We should be able to protect it. We definitely want to be aggressive here. And you need to make sure that you counsel them on what it will really look like as far as potential business disruption, what kind of, who might be deposed, what that prep looks like, who would have to be involved in document collection and review and production and the costs on that end. Can be significant. And also, what sort of information your client might need to reveal if you do file an affirmative case. If you're filing an affirmative case and you're going to seek damages, well, then the defendant's going to be able to get discovery into that business line. And yes, of course, you can have a protective order and you can limit how that information gets disseminated. But oftentimes, I have found clients and their business partners internally say, wait, what do you mean we have to produce numbers on our market share? And yeah, you do, depending on the scenario. Sometimes you can fight it and other times you can't.
Yeah, it's a great point on the business disruption. And I think in particular, I found that, the team that's affected is can matter a lot too. If you're looking at a part of your business that might be involved in litigation, whether you've got a threat or whether you're considering offensive litigation, talking to the people on that team and just letting them know this is going to be a disruption and are you busy? Are you working on company critical functions right now, such that taking 2, 3 days of time away from multiple people on that team might be a huge problem for the company, and maybe that affects your willingness to settle or how much the business might offer to settle, because it might just be worth making something go away so that you don't have to. take time off of everyone's calendar. And I think, people who haven't gone through the process don't fully appreciate that a deposition is not just the day of, and it could be all day. It's all the prep that goes into it. It's all the, gathering documents, and it really can be a ton of time both for, in-house counsel and for the business stakeholders.
Right, right. On top of exposing those deponents to being asked about aspects of the business that they are might not want to have to discuss. Okay. Um, so we've covered a little bit of this so far, but with the litigation leverage framework, you have your rights sort of top center, you have the procedure. Where are you going to file? When are you going to file? What kind of matter are you going to file? Timing, economics, which was discussed last session, and then outcome. Um, some common strategic mistakes, thinking broadly, focusing exclusively on the merits. I think, sometimes people get very focused on, well, we should win because we are right. This is our technology. We should be able to protect it. It's strong. Or on the other side, we're definitely not infringing. That argument is strong. And you might lose on the merits. I mean, you might have a great case and get a bad judge or a bad jury. So you do have to think about not just the merits, but do you have strategic leverage in other ways here?
Yeah, and I think it's important to think if you're looking at the merits, even if you have the right side of the case, looking at when you can achieve that victory is really important. If you can knock something out on a early motion practice, a motion to dismiss, great. You're not investing a ton of time, you're avoiding discovery. If there are factual disputes that you see at the outset and you know you're not even going to win on summary judgment, then you're planning on tons of, outside counsel litigation costs, all the discovery and then going to trial, which, as everyone knows, can be a total crapshoot. And so, even if you feel strongly, I think it's important to look at when could we win? When could we, prove our case? And that is a really important consideration, at least for us.
Yeah, I think that goes to this third point here, the failing to evaluate timing strategically.
Mhm.
All of that is very relevant. And and exactly how long can your client wait for that relief? If it's really important, just say, okay, is it going to be important to you 5 years down the road when
Mhm.
when we're finally resolving the case? Um, and this fourth one here, missing opportunities to create pressure early. That one is, I think, really key. It's going to be probably beneficial on all sides if you can get an early resolution. On the plaintiff side, you're not wasting a lot of money on discovery, and you can maybe get an agreement with the other side quickly. Defense side, same thing, and you have clarity for resolution. And there's opportunities to create pressure on both ends. We're going to get into offensive tools next, and then defensive tools. But really thinking about that critically at the beginning of the case. Do we need to file injunctive relief on the same day as we file our complaint? Are there aggressive tactics we can take on the defense side early on that will create pressure? And I would add in here another common strategic mistake might be not attempting resolution early. Like early mediation can sometimes be really effective. Not in every case, but if it's possible, it's worth exploring. Okay, offensive tools. Choosing when to strike. We spoke about timing a lot, and we'll talk about it even more as we continue the session. But, filing first can influence forum and procedural posture. And, if you know that you're going to be in a dispute, do you want to file a declaratory judgment action on your home turf and hope to keep it there? That's a common strategy. Another piece of the puzzle to think about is that waiting a bit, I wouldn't necessarily call it delay, but allowing time for additional facts to develop could be helpful here. If, let's say, you're in a trademark litigation, a trademark dispute, you send a cease and desist letter, you put them on notice. Well, now any sales that occur after the point of your letter and up into the point where you file your complaint are going to be sales that you can say were made with knowing with knowledge of infringement, and maybe you can get enhanced damages from that point forward. And, there might be some pre-suit investigation you need to do between finding out there's an issue and being able to file the strongest complaint that you can. Um, and of course, the timing should support business objectives. This one is tough. It might be that there are stakeholders within the company that want to wait to file litigation because of something that's happening on the business calendar. And you are also going to need to think about that with respect to the court. You don't want to be in a latches in a situation where the other side is arguing that you sat on your rights, and it's because you waited for strategic reasons, strategic business reasons that aren't going to hold up or will affect your rights in court. Scott,
Yeah.
and
And I think to add to that on the timing, I think it's important to again talk to the business stakeholders and see whether something is actually affecting the business. And that might be, instead of choosing when to strike, even whether to strike at all. If it's something that you look at it as a lawyer and you say, this is infringement, we should do something about it. If you go to the business and they say, this hasn't actually affected us at all, and filing suit is probably going to be creating a bigger burden, maybe you hold off. Maybe you just monitor and evaluate. And as Lindsay said, you have the risk of laches to worry about or other equitable defenses. But if it's really not truly a business problem, is it even worth pursuing? I think is something you should always consider as well.
right, when we were in our prep session, Scott and I were discussing, examples of some of these strategic questions, and I remember a matter where we were fighting tooth and nail. The business side was very upset that their technology was being used. We were trying to create leverage in the case. We were simultaneously trying to negotiate settlement. We're getting back and forth on settlement terms. And then one of the terms is talking about, whether whether the defendant should be able to use the technology for the next year, and then the defendant would have to roll out something else, and we would allow them basically like a license for a year, and what would happen after that. And they were asking for more than that. And as we go along, and this case has been going on for 2 years at this point, our business side said, oh, well, we're not going to care about this technology in 18 months. We're abandoning it too. We're moving forward to something else. So, forward looking, we actually don't care about it as much. It's more about the past harm. And we've been fighting about this one term, and they had kind of neglected to chime in with that at that point. And so it's just good to be aligned on all of those fronts, especially when you have, you often in your role, you're the sophisticated legal in-house person, and you're talking to very, people who are very technically sophisticated at your companies, but they might not be sophisticated within litigation. And so bridging those um, uh, concepts and strategy considerations is important.
Yeah, great point. And I think a common theme is talk to the business and talk to your
Yes.
stakeholders because there is a lot that you may not know and important considerations that they may not realize are important to you. And so I think just having good lines of communication, really knowing what's going on, what's important to them is key for all of this.
Yes, and I can't recall if it comes up now or later, but we can discuss it now. We're talking about the pre-suit communications. When you talk about the business side and knowing what your rights are, you really want to make sure you have a good and candid conversation with the business stakeholders before you take any action. Because you need to know where the skeletons are hiding. They might, in general, feel like they have a really great position, let's say on a trade secret claim, and then you send your pre-suit cease and desist letter to the other side, and the other side comes back and says, this has been freely available on the internet for 4 years. So, and you haven't taken any action. So how is this your trade secret? It's good for you to, I mean, you do your own investigation, you have your outside counsel do the investigation, but to just make sure you ask the right questions. I think, Scott, you had a similar sort of exemplar in your mind.
Yeah, I've been on both good and bad sides of that. The good side is, I think, probably the most fun thing for a trademark lawyer is to get a cease and desist letter and you actually have prior rights. And now the sender has just admitted infringement. And they didn't do their diligence. And I've also been in cases where the business will come and say, "Hey, look, this company's infringing what we're doing," and they're worked up, and you send the letter, and then they come back and say, actually, we were doing this first,
Right.
um, and then you're kind of caught in a bad place. And I've actually been in a situation where we've sent over a present to a company whose marketing team had to get spun up, and they got a nice little delivery of cookies as an apology, basically. So, doing diligence ahead of time, very important.
Yeah, yeah. Um, okay, so as we're talking about demand letters and pre-suit communications, can often be helpful to clarify positions. If you send a cease and desist letter and you actually get a response from the other side, then you get a little preview of how they might defend the case if you brought one. Um, Preserve settlement opportunities before litigation is filed, influencing future litigation dynamics, and I would say also establishing your ability to seek enhanced damages, perhaps after you put them on notice of infringement, and to demonstrate seriousness without immediate litigation. Although I will say, and I think Scott, you agree, we talked about this beforehand, is you really want to check everyone's gut to say if we're sending the cease and desist letter, is it an empty threat, and you don't want to, think about the consideration of if you send these and then you don't take the next action, is your next cease and desist letter going to be completely dismissed? And
Yeah, exactly. You lose credibility. Then they know, hey, this company's not going to do anything. We do have a question in the chat from Michael Dunn. If you don't send a cease and desist letter to an infringer, doesn't it set up a situation where you can't enforce your patent? Lindsay, you want to take that one, or I can field it?
yeah, since you're more on the patent side, I'll let you, or you had more experience previously. Yeah.
Yeah, I think, it's looking at sort of the defenses of delay, essentially. And I think if you're aware of an infringer, you don't send it right away, that's not gonna kill your patent rights. But if after a certain amount of time, if you wait too long, you're cutting off maybe the damages look back period. And I think, on the trademark side too, if
Yeah.
you're policing your mark, and you can lose your rights, and that will be taken into account. If you let six infringers go and the seventh one you decide this is too much, I should go after them, the defense is going to be, well, these are the other six out there you haven't done anything about, so therefore you're not policing your rights, you're losing them. But I think it's all a matter of, the timing, and it's not an immediate loss of rights, but it's something you want to monitor and pay attention to.
Yeah, I agree. In the trademark situation, it's more important because there's that requirement, and you're not to police your rights and establish where you are in the market versus what we're looking at in patent as far as like prior art and um, whether you have shown that you have a patentable invention, and then separately, okay, did you wait too long to enforce? With trademark, the question of whether you still have the mark is constantly technically being reevaluated. You can certainly abandon a mark by not policing it. So that is important. I will say it depends. I think when you're thinking about it, and I'll just answer in the trademark context, you also want to think about, are you sending a cease and desist letter to everybody who posts something on social media? Or are you focusing your efforts on somebody who has like 1 million followers, and is actually affecting your brand in some way? You have less of a risk of showing that you're letting all these infringers off the hook or you're abandoning your rights if you're, with respect to, I'll say, people who have a much smaller influence or viewership, right? You don't have to go over every single tiny small potato, but you can't let the ones that are risking your brand sit out there.
Yep, good point. I also want to talk a little bit about being on the receiving end of these letters, because I think, especially on the patent side, I would imagine most people on the call are getting, letters from non-practicing entities and deciding how and whether to respond. And we get many as well. And I think, one of the things that I do is do some diligence, research who this non-practicing entity is. Many times, someone has sent out 1,000 letters, and they're only going to engage with the people who respond. So many times, ignoring a letter could be the way to go, and we've had success with that. But then taking a look, check the dockets, see if they've actually filed suit against anyone. If they haven't, good chance they won't against you. And ask around. I usually will kind of ping outside counsel and say, "Hey, we got this. Are you familiar with this entity? Any experience with them?" That is usually very helpful as well. And then if they have sued people, what I've done is reached out to in-house counsel at the other companies that have been sued, to talk with them, see what their experience is like. Maybe you have an opportunity for a joint defense group where you can pool resources. Um, and just understanding, what their experience has been is really important, I think, in terms of how you're responding. Can you delay? Is the suit imminent? Is this a serious threat that you really need to start, putting legal holds on for and things like that. So I think on the receiving side, there's a lot you can do that will help you understand what your best move is going to be.
Yeah, definitely. Um, okay. Venue and jurisdiction strategy. We talked about this a bit about consider convenience and efficiency on your end, assess procedural advantages. Do you want to be in a rocket docket? Evaluate the judicial experience with your that you either have had previously in your own experience or your outside counsel's experience, and align the forum with litigation objectives, get a sense of, how friendly are they to plaintiffs, how friendly are they to companies who do the kind of work you do. In general, sometimes it's going to be a bit of a crapshoot, and some jurisdictions are a little bit more knowable than others. And Scott had a really good point when we were prepping for this to talk about. You think about your business objectives, about where you're gonna have people situated. Do you want to avoid having offices or servers in certain parts of Texas as a company? If it's not otherwise incredibly important to your business to be there, are there jurisdictions you want to physically avoid? Now, that's a much bigger question, but it's worth it, especially if you're talking about server space, I think, because the courts kind of all over the place on how much of a connection to a jurisdiction you need to be able to be sued there. And I think any point of contact creates the risk that you could be sued in a jurisdiction, depending on what judge is evaluating the question.
Yeah, super top of mind for us and many people that I talk to is, yeah, having, not only just the physical presence or server presence, but even having employees there, even if they're just remote employees. You don't have an office, but you're about to hire someone in the Eastern District of Texas. What does that look like in terms of uh, someone's ability to pull you into a suit there? And typically the courts are looking at, like, did you put that person or these people in Texas because you're trying to target the local market? Maybe you're trying to sell to the energy industry or something along those lines.
Mhm.
Or was this a national job posting, and the person who responded just happened to be located there, and their work really has no connection to the location? Then less likely that you'd be in trouble. So important things to think about.
Right. Yeah. And I mean, the fact that work is so remote now makes those questions. I think it will be interesting as we move forward and see how the jurisprudence evolves on personal jurisdiction. Who, where is somebody working when their company is based in California and they live in Montana? I agree with you that if this person is not central to the facts of the case, it's going to be irrelevant. If that person is directing calls and meetings and taking actions from Montana, then um, they have a much stronger argument. But that's why that's why you still, these questions which the courts have to wrestle with and this happens in all parts of IP litigation, is that you have these rules and laws and rights that were written hundreds of years ago, and then the technology keeps evolving and creates novel questions for the court to consider to put it into this framework. That it's very interesting, but does make it hard to advise your clients sometimes on how the court will rule on jurisdiction. Um, okay. Declaratory judgment actions. That's, you know, one avenue that you have instead of waiting around to potentially like be sued about from somebody who's accusing you of infringing to get the eliminate uncertainty and created by threats and have the rights decided by the court. They can provide greater procedural control and influence venue and timing, force issues to be resolved proactively. However, you could be accused of form shopping, of being not the proper plaintiff if you're just filing first to say, like they used to say when the internet was new in forums, first, the first comment was just first. It sort of feels like that sometimes, and then you can be subject to a motion to transfer, not just for lack of personal jurisdiction, but for forum nonconvenience. And I've seen those be successful in cases before. I didn't know if you wanted to speak anything more you want to add on DJ actions, Scott?
Yeah, I think one thing we consider, and I think is important consideration is if you've got, maybe a cease and desist letter, a threat against you, considering whether that is actually going to turn into a lawsuit. Because if you file a declaratory judgment action, you're guaranteeing a lawsuit essentially. But you might be able to resolve it before they even go to court. And so you have to really consider how serious is this threat. In the example I mentioned earlier, where we did file a DJ action, that ended up being transferred. That was a case where it was very clear this was a big company. They had a track record of doing this. They were going to sue. And so that was a easier decision. But I've definitely considered, um, especially, in response to some non-practicing entity threats, um, and where, venue is really important. Do we want to get ahead of this? Or do you think we can just resolve this? And, filing a DJ action all of a sudden ratchets up the pressure. You may be dealing with someone in their business who's a licensing person, and then it goes to an outside law firm that's going to be a little less willing to negotiate and settle. And so it does kind of raise the stakes a lot more. And that may be great in some cases where venue is really important and where you are is really important. But it's also a risk you're taking that they might not have sued you, and by filing the action, you're kind of guaranteeing that they're going to come at you.
Right. And that reminds me of another point that I want to make about declaratory judgment actions. Don't expect that it's just going to stay to year one, you know, request for declaratory relief. This might become an expensive, protracted litigation. They might bring very significant counterclaims against you. You might see an antitrust counterclaim. Um, this it's not necessarily going to turn into just a very clean, straightforward, fast-tracked litigation. It can still be important, but I just think it's something to keep in mind that anytime you're filing a case, unless you settle it, you're going to be in for the long haul, or you should be prepared to be. Um, okay. Offensive strategy playbook. We talked about this. So define desired business outcomes first, select tools that support those outcomes, create leverage before costs escalate, um, and maintain flexibility as circumstances evolve. We're about to talk about defensive tools, but one of the pieces of creating early leverage that we'll talk about after we talk about general defensive tools are preliminary injunctive motions, which can be incredibly important on the offensive side. And while those are not cost-free, they can be incredibly effective if you're successful in them before discovery even starts in earnest and really change the positioning of the parties. And then maintain flexibility as circumstances evolve. That's important on both sides. Don't just keep thinking about the case the way that it started in your mind or ideally looked when you plotted it out. As you discover new facts, as you get a good or bad ruling, you should be adjusting your strategy.
Yeah, and one thing I'd add to this too in these considerations is cleaning up your own side of things too before you go after somebody. If you're considering suing someone for patent infringement, take a look at what their patents are and what counterclaims they might be raising against you, and decide whether that's worth it. Or, commonly, if you're kind of sending a cease and desist letter to a competitor who is maybe making false representations about your company, look at your own materials. Maybe, they're going to be looking at your website too and saying, all right, well, here's five things that you say about us that are wrong. So, really kind of thinking through what will the reaction be? What's the blowback and how can I get ahead of that? Because at this point, if you're in the offensive side, you're in control. They don't know what's coming, and you have time to clean up your own house and really get yourself situated so that any counterclaims you're well prepared to address.
Yeah, that's a really good point, especially before you file the sort of leverage that you have. And, just in general, I don't think I've been in a case, a big enough case that doesn't have some bad document. There's always something, some careless email somebody sent. On both sides, you're excited when you get it from the other side, and you're banging your head against the table when it's your own client or your own company, and somebody who's like, I don't even remember sending that. I mean, yeah, that's how it goes. I don't remember every single email I've ever sent. That's why as lawyers, we draft our emails very carefully. On the business side, they're out there taking different risks and doing different things and not thinking about every single communication they sent from a litigation framework. But I will say the best piece of advice I got, one of the best pieces as a very young lawyer, was to dance like nobody's watching and email like what you're writing will be on the front page of the New York Times tomorrow. Um,
Yeah, great point. And I would add to email, I never used Slack when I was at law firms, but now that I'm in house, Slack is heavily used, and that tends to be an area where people assume it's this fleeting message that goes away, and so they're even probably more careless in Slack than they would be by email. And that is both a gold mine if you are seeking discovery from another party, but also could be a source of of bad documents as well on your side. So important to think through like those communications where people might be a little more casual, like maybe text messages, maybe Slacks, things like that.
right, right. It's when I'm doing custodian interviews and I ask them, do you ever use text message for business purposes? Or is it something just like, hey, running late to the meeting? And I'm always hoping it's the second one, but more often than not, it's like, oh yeah, no, we use text for everything. So, um, all right, moving to defensive tools. Um, this the early assessment and risk triage it's similar pieces of the puzzle that you're looking at from the defensive side. Evaluate the merits quickly. How exposed are you? What are your defenses? Of course, that's the first thing everybody wants to know when they're sued. Does this case have any legs? Identify the business exposure. Does this relate to a specific product or other related products? Are you about to have a big launch and this problem, and once you do, the plaintiff suit's going to get even bigger? Um, Preserve strategic options and prioritize high risk issues first. Um, I'm going to just jump to the early motions unless there's something you want to add on this, Scott.
Yeah, I think one thing to consider is kind of the flip side of what I was talking about before, if as an offensive litigation strategy to kind of make sure your ducks are in a row. On the defensive side, thinking through what you can use to leverage and put pressure on the plaintiff or the person who's or the company that's coming after you. Maybe they've got patents that are vulnerable and no one's really challenged them because they just settle and go away. And maybe you can apply a little pressure and say, look, we're gonna invalidate your patent, or we found these holes in your line of ownership for your trademark rights, and we're gonna poke holes in those and potentially cancel your mark if you want to pursue this. And so kind of looking at what leverage you might be able to have to kind of make someone go away. We had a case with a non-practicing entity sent us a license demand for their patents. And we looked into it, and looking at all the methods in the patent, they were not all performed well, I mean, our position would be none of them were performed by us, but for sure, parts of them were performed by a third party. So there's a divided infringement problem, and we actually pointed that out, and they just simply went away. And so, having those kind of early leverage discussions can be really helpful and kind of making what might be big problems either smaller or just go away entirely.
Yeah. Um, okay. And I would say, when we talk about prioritizing high risk issues first, um, you know, if you really want to assess like what parts of the business are affected. You're looking at the complaint and you know what the plaintiffs allege, but are there actually different pieces that are going to be implicated going forward that are going to come out in discovery, things that you know that the plaintiff doesn't know yet, might find out in discovery, might amend their complaint. So really, excuse me, thinking about the big picture of how exposed are we in what areas so that they could make appropriate decisions. Because damages might be, I mean, if you are found to infringe, damages are accumulating during the pendency of the case, unless you stop what you were doing, stop selling your product or change or pivot. And maybe you were about to pivot, and now this is the business side's way to at least cut off, forward-looking damages and pivot because you were going to move off that technology anyway, if you think there's a particular risk. Uh,
Yeah, it's a really good point. I think, talking to the product team or the engineering team and saying, look, is there another easy way to accomplish this? And if so, why don't we just switch to that? So if something does go wrong in the down the road, there will be a damages cutoff point. And that, if it's an easy fix, great. If it's expensive and complicated, then I think you need to consider what is our real risk of losing here? And is it worth investing the time now to change what we're doing?
mhm. So early motions to dismiss, obviously, venue challenges, both, don't forget about forum non-convenes along with personal jurisdiction. Is it going to be a burden to move to have witnesses travel? Um, and have court appearances and whatnot. It's interesting because forum non-convenes arguments they still do matter even if most of your hearings are remote. Trial wouldn't be remote. At least I haven't heard of any Zoom trials happening in the past few years. But you don't forget about those challenges because you can still make them. Um, and early summary judgment opportunities, which I think Scott can speak to. Before I hand it over to Scott to talk about the effectiveness of that kind of motion, I will say that sometimes for the defense, I mean, really, you maybe delay is your friend. So, bringing a motion to dismiss, there's six claims against you. You think three probably are going to go forward, and three are ripe for some kind of motion to dismiss to at least get a better um, more substantial complaint, get an idea of what you're shooting at. And certainly in federal court, you might not have a hearing or ruling on that for a year to 18 months, but maybe delay is your friend in this case on the defense side. Often, plaintiffs want to speed to resolution, and defendants often can want to push things out and make the plaintiff a little anxious and more interested in settling. Um, I will say, on the other hand, sometimes you don't want to bring a motion to dismiss because you just want to, I mean, sometimes that just helps the plaintiff improve their claims. You can be strategic about whether it makes sense for you to do that. And yes, so Scott, on the early summary adjudication options.
Yeah, and real quick before that, on the jurisdictional defense and kind of the motion discovery or the motion practice that can go along with that, I think it's important. One really important tool if you're facing like a motion to dismiss for improper venue or transfer, is taking jurisdictional discovery. That's
Mhm.
always an available tool. I had a case where we filed the claim. There was a jurisdictional motion. We took discovery, had days of depositions of the defendants, and it turns out that they lied in their declarations about their business in that particular forum. And so not only do we keep the case there, we got sanctions, we got our costs for all the discovery work. And so it's really can be a very, very powerful tool. Um, but going to early summary judgment motions, yeah, I think, in terms of what I was saying before, when you're evaluating the case and are there opportunities to get rid of the case early, maybe there's a discrete portion of the case where the facts aren't in dispute and you can really narrow the case early. That can be a huge saver of both of time and money. If you're eliminating a few claims and before discovery has kind of run its course and there's no more discovery needed there, you can really kind of knock out a portion of the case. Maybe you're freeing up a part of your business. Maybe there's, discovery or other things that you might avoid. So kind of looking for those opportunities, even if it's not on the whole claim, where you can kind of simplify the case and knock it out, can really, streamline and maybe put you in a better settlement position too. Maybe they had three claims and only one was this that they view as a strong one. If you can get rid of that, maybe you're kind of putting them in a position where they want to walk away and you get a better settlement result.
Yeah, very good point. Challenging validity and ownership. We mentioned this at different points in this session. Patent invalidity challenges, trademark, copyright ownership disputes, um, trade secret identification deficiencies. Yeah, I mean, you always have the ability to either within the same litigation or by going to the PTAB or TTAB to challenge the rights. You could also bring a counterclaim challenging the rights or seeking a declaration of invalidity. And on the trade secret identification piece, at least in California, when you have a trade secret case, there's very specific procedures that you're required to follow. You have to identify your trade secret with particularity. You have to identify why it's a trade secret. And I have been in extensive back and forth motion practice on such disclosures before it was on the plaintiff's side, and the defendant really put us through our paces, and the court sided with them multiple points along the way and said, you need to provide more detail, you need to provide more detail, you need to provide more detail. Those can be really important, especially on the defense side, to require the plaintiff to articulate what are you actually saying is your trade secret so I can put it in this box and I can understand if we have been using any of it. On the trade secret side, you have two pieces of the puzzle, right? You have like, did it come to you in an inappropriate way? Did you get this information? And then was it used or incorporated in anything? Those are two very different questions.
Yeah, and I think it's important to remember that just because the USPTO issued a patent or a trademark or the Copyright Office granted a copyright doesn't mean those things are now, not subject to attack. I think the
Right.
percentage of patents that get invalidated, I haven't looked at it recently, but at one point it was pretty high, 30 to 40%, something along those lines. So, um,
Yeah, same is true. I mean, there's that I won't say the exact because I don't know the numbers exactly, but yes, certainly I would say the same for trademarks. There's oftentimes where we look at something, we're scratching our head and we're like, how did that make it through? Who was looking at that? Yes, so I agree with you
exactly.
there. Yeah.
Examiners are very busy people. They have a lot on their plate and they often make mistakes. So, yeah,
Yeah.
always something to keep in mind.
Yes. I know we're down to the last few minutes. I do want to hit injunctive relief, before that, just to review defensive strategy, identify pressure points early, challenge assumptions aggressively, which is what we were just both speaking of, even as to validity, focus on business objectives, and seek opportunities to narrow issues. Um, Injunctions and emergency relief. So, injunctive relief can be incredibly important in certain IP cases. I will say in a trade secret dispute, it's almost required, I would say, in my experience, if you're bringing a trade secret claim, um, you want to prove, A, that this information had value by being secret and that you're being harmed by someone else using it. Well, if all that's true, you should be needing injunctive relief to stop them immediately. Otherwise, you're going to have a hard time on the other end proving that you were actually damaged by this. So they really go hand in hand there. And for trademark enforcement, it's incredibly um, valuable. It's valuable in any case, but it's incredibly valuable to basically have an early decision that you're likely to succeed on the merits, and that that the defense has to stop using your mark or change the way that it puts their product together. I mean, it's handing you a very early positioning point, and unless the other side, unless it's essential to their business, they're oftentimes going to want to settle with you early if you're able to obtain injunctive relief. Scott, anything to
Yeah.
add on?
Yeah, I think in the patent context, a little bit different. In my experience, I think it's pretty hard, and preliminary injunctions aren't as common because you're still early in the case. There's no claim construction. There's no, then it's so dependent on pretty significant discovery. Um, but then the permanent injunction at the end of the case can be really significant. If you're having to redesign a product. Um, or change how you're doing business, that can be really disruptive. And I think important, like we were talking about before, it's important to evaluate what that involves and what that might look like while the case is pending or while it's beginning, just so you have an idea of, like, if this goes wrong, what is it going to take to comply with any injunction that might issue, and how burdensome would that be?
Yeah. Um, Types of emergency relief: temporary restraining order, which is just put in place in a short period of time until there can be a full hearing on preliminary injunction. Expedited discovery, if you need to find out where more defendants might be located or assets might be located that you need to seize, or seizure orders where available. I know in my practice dealing with counterfeiting claims, often filing along with the complaint, or filing the complaint under seal, filing an application ex parte for a temporary restraining order and asset freeze if you happen to know where the defendant's accounts are located. It can be very effective. Now, those kinds of motions are a little bit easier when you have something like counterfeiting, which is easier to establish in a preliminary hearing of likelihood of success on the merits. When you're talking about infringement, where the court's really weighing a very factually intensive case, it can be more difficult. Um, Okay, well, we are at 12:59, and I promised that you guys would be able to get to kick off. So I will say, if we just have any remaining questions at the end. We talked a lot about business alignment and points along the way to create strategic advantages. And I think these last few takeaways are really the core of it here. Okay, I can't see the comments.
No
Okay.
comments or questions in the chat.
No comments or questions in the chat. Okay. Well, thank you, Scott, and thank you everybody for showing up today. We appreciate it. And I hope that you will be hanging out with us for the last session, um, which is, oh, it's not on my screen, but there's a fifth section within this series. Let's see.
And it looks like I'm wearing the same shirt as I was wearing in that headshot, so that was not intentional, but good
Well,
coincidence.
Scott, I almost did the same thing because I almost wore that exact same dress. So I'm glad that only one of us did that. Yes.
I swear I own different shirts.
All right. Well, thank you, everybody.
Yeah, thanks everyone.
Okay,
Thanks,
bye.
Lindsay. Bye.